Sharing is caring, and since it's a lawyer, sharing really is scaring. I'm going to try to scare you a little bit, not so much scare you into thinking that lawyers are bad, but but really scare you with some real life situations that I've come across and how you can potentially avoid those things, or even help other people that you know to avoid them. So again, I'm Brent. My background is I'm an attorney. I have a deep business background as well. Thank you for that introduction. So I'm not going to go too deep into that, but the most important thing to know about me really is this. It's my, this is really why I do everything that I do. My family, the experiences, these are the people that I do everything that I love to do. How do I get rid of this, by the way? Can you see this or no? Okay. Can everybody hear me okay?
Yes, I was wondering where you collected all those kids.
Just off the street, street. So we're doing some case studies in what not to do. And these are actual clients and real life situations that I've seen. So screw up number one, I call it Paperwork Sucks, Inc., a corporation that began more than 5 years ago, 2 stockholders and an investor. Original agreement was to have the 2 co-founders own 50%, the original investor have another 50%. They didn't do any documentation, and then the business took off. Why is this a problem? This is actually a good situation, right? Stuff happens though. The investor paid in nearly $1 million with no documentation, and causing some problems, including that investor, started to have some marital issues. Company brought on some key employees they wanted to give equity to incentivize them to stick around, but the company still needs more funds to grow. They have a lot of interest from new investors, but that original investor doesn't want to give up any of his preferences. It's causing major marital issues for him. Like we're talking literally like if we bring on an investor, his wife's going to divorce him. It's been really interesting thing, but the lack of agreements is also translated into other areas, no financials, no employment agreements. It's chased away a bunch of investors. So obviously this is a screw up. It came down to the wire a lot of times for funding. They were behind on paying payroll a lot of times, a lot of stress and anxiety, high legal costs. And then when we do create the equity incentives for the employees, they're going to have some pretty big taxable events. And it's actually forced the founders to act as marriage counselors to their investor. And I don't think that's actually ever a good situation. How to avoid this mistake? Really, you need foundations in your business just as much as buildings do. This means having articles of incorporation, bylaws, shareholder agreements for LLCs, having your operating agreement, making sure you're doing your meetings. These can be burdensome, but don't underestimate the benefits of having these early agreements, because it limits the risk, allocates the risk. You make decisions before the emotions run high. You can remove the obstacles to your business and then really put yourself on a pathway to growth in case your business does move forward the way that you want it to. Screw up number two, I'm talking about Brand Name Inc., a company that started in 2011 offering consulting and education services under an intuitive brand name or a descriptive brand name. Intuitive brand names are things like Beard Baron, Ganesha, Standout Marketing Agency, Aquaman Pool Service, something that is kind of like obvious that this works out as a name. And so after 8 years of impressive growth, they were an established part of the community. And then instead of registering their trademark initially, they waited. So why was this a mistake? You'll find out. The trademark was examined and they found another very similar mark, Brand Nom LLC, that offered consulting and education services in a related but not identical industry. They registered their mark immediately. And so brand names options were to rebrand or work out an agreement with Brand Nom to allow both. Or to initiate cancellation proceedings. Now, common law rights are they have the rights in the mark. They actually do have the right to take them down if they wanted to, but that's a very expensive process and procedure. So how to avoid this? You need to be deliberate in your branding process. The more fanciful the name, the more protection it's going to get. As an example, like for example, if you were to say Dr. Group, for a medical group, that's probably not going to be really protectable. That's very descriptive, and likely other people are going to call themselves a doctor group, right? And then search early, search often. There are services out there that you can check to see who's got your name already out there so that when you're doing the naming process, that you're already aware of this. Now, naming a business is one of the most annoying things you can possibly do. And you can spend $25,000 to $200,000 to establish a brand. How terrible is it if you have to like rebrand later on because you did not just do a Google search? You can talk to an attorney, but I'm telling you right now, attorneys do like to have money. And if you're going to be choosing to pay your attorneys over develop your business, that's not a good option. You always want to consult attorneys to understand your strategic options. You don't just necessarily want to have your attorney to do it all for you. So use your branding professionals, including your lawyers, carefully. Build those relationships and make sure that it's your lawyer, your branding people, your CPA that you're developing the relationship with so that you understand that they're watching out for you and your interests. So the last screw up that I'm going to go over right now is paperwork sucks. Redux LLC. That's a patent that issued in 2015, and they built a whole business around it. 3 partners, no operating agreement. So again, that's another screw up. Then they took off. Stuff happens. One partner got bought out, another partner got divorced, and then they brought on 2 key employees to come on board that needs incentives to stay. It's now a multi-million-dollar brand in the industry, but the partner who left has tried to sue them for those patent rights. Now that's kind of terrible, right? That they've been commercializing and is now a multi-million-dollar product. The divorce partner ended up losing his membership interest in the business in the divorce. Guess who ended up with that member's interest? I'll tell you right now, like sometimes you go to work, you don't necessarily like to work with your partners, and you got into business with them because you wanted to get into the business with them. If you're getting into business with an angry ex-spouse, that is not a good day. So I know this is kind of facetious. Why was this a screw up? I mean, let's go over the ways, right? They're dealing with potential litigation over their crown jewels because they didn't have it assigned over to the business. That owner of 1/3 of the interest in the LLC never wanted to be there, does not want to do any of the work to make the money happen, and it's not going to be cheap to buy her out. And the 2 key employees have had to wait years to get their equity, and they're going to be taxed at a pretty high rate because we're talking about a multi-million-dollar company that now they're a part of, rather than having gotten that equity in the beginning. So you can either avoid having partners ever, and there are some people that will tell you this is the right way. Now, it could be the right way for you, and it might be. Maybe you just hire. You just hire it out. You don't bring on partners. But if you do decide to have partners, you want to make sure you set up the business properly. You also want to make sure you set up the business properly with only one person, but all of the problems become exacerbated when you have multiple. So you want to limit your risk. You want to stimulate some conflict. Now, you might think that that's a little counterintuitive. Stimulate conflict in the beginning before the stakes are high. Find out how you manage conflict, navigate issues. Make decisions before those emotions are high. Remove the unnecessary obstacles. And as a pro tip, make sure that the intellectual property, the patents, the trademarks, the copyrights are assigned to the company so that the company can leverage it in case somebody leaves and tries to assert their own rights to the IP. I don't know if anybody watches Shark Tank, but one of my favorite episodes is when all of the sharks are bidding on this patented process, and then they find out that the lady had a patent that was actually partly owned by her ex-spouse, and everybody was just out like trout. Just nobody wanted it anymore. And so if the business had owned the intellectual property, there would not have been that problem. So to recap, investment in legal work is just like other investments you make in your business. You got to learn the issues, know your options. Stimulating conflict can be a good thing. Have these conversations. Who owns what? Who does what? What happens if one person wants to sell out? What happens if one person's not pulling their weight? All of those things need to be answered before you get into a higher stakes situation. Be deliberate, have a plan, and then use legal services to achieve your plan. It's just like baking a cake. It's not just about the ingredients, but also the syntax. You don't want to put in the flour after it comes out of the oven. You need to put it in at the right time in the right way so that you get the product that you're looking for. You find good coaches, use them. And again, we're going to just let Drake, since Drake says it best, paying attorneys over developing your business. No way. Consulting attorneys to understand your strategic options. Definitely want to do that. So any questions? And if not, I'm going to go ahead and pop it to the last slide there. And did I go over by too much, Rose?
No, no, you were right on, actually.
Awesome.
So you mentioned for LLCs, it's important to have an operating agreement.
Correct.
Would you elaborate on that just a little bit?
Absolutely. So This is recorded. So anything that I say, by the way, is not considered legal advice. I'm going to give some broad educational guidance here. Arizona statute, if you don't have an operating agreement, you do have the Arizona statute to serve as your operating agreement. But there are pieces of the statute that you may not like. Like, for example, it imposes a fiduciary duty of loyalty between the members. And if you don't want to have fiduciary duties to your partners, you need to disclaim that in an operating agreement. There are other things that you want to make sure of. If there are ways that you don't want it to go according to the statute, LLCs allow for very flexible options for distribution. If one person puts in time, one person puts in money, and then part of the deal is that the person who gets the money is going to have the first money out. You want to make sure that that's written in there. If you want to have the person who puts in the money get a specific amount back as a return on putting that money, that needs to be highlighted and put forth in the operating agreement. If you don't have the operating agreement, then you're basically just at the risk of the statute. Now, in a single member LLC situation, that is the one place that I could see potentially rolling without an operating agreement, because the bulk of the issues that arise in the LLC statute come because you're talking about multiple members and how to navigate conflict between multiple members and making decisions. And when there's only one, the question is moot, right? I mean, it's just one person who's going to basically he's on the hook for all of the expenses. Well, the business is on the hook for the expenses, but it's going to be the single member who's on the hook for making all of the decisions. In multiple member situations, you have some defaults. If you don't like those defaults, then you definitely need an operating agreement, because the statute does allow you to make your own choices. And let's be real, if you could guarantee that the business was going to go good, that everybody was going to make the money that they wanted to make, you probably wouldn't need an operating agreement. But real life doesn't work that way. And so the operating agreement is the rules of the relationship for when things go wrong. Because if things go right, you can always make a new deal. You can always amend it. You can always shake hands and do something different than what's on the page. What's on the page, that's your worst case scenario that everybody has already agreed to. And so you need to make sure that it's something that everybody can live with.
These are all very good points. And the points about the spouse,
yes,
I found was incredibly relevant. I've seen situations like this, or what happens when one of the parties wants to retire.
So
wants to stop actually. So you have to have this covered. And go ahead.
Yeah, you do. So it's either going to be covered in the operating agreement, or in a buy-sell agreement, which is another common agreement that you should be definitely looking into if you have partners. Having a buy-sell agreement in order to basically go through with people, how you are going to divvy things up if one person dies. Do you want to be in business with a grieving spouse or grieving kids? Because, in Arizona, the heirs are going to inherit if you don't have something in an operating agreement that says otherwise. And that's why, in an operating agreement, because Arizona is a community property state, even if you own something, if you built that business, while married, then your spouse does own basically an equal share of your percentage interest in the business. And so you need to make sure that your spouse is willing to adhere to the provisions of the operating agreement also. But yes, definitely you want to get an operating agreement, want to make sure that it covers retirement, buy-sell provisions. And really the answer to that question, Rose, is what do you want to have happen? If you don't have a buy-sell agreement, or buy-sell provisions in your operating agreement that discusses that, then the reality is that you'd have to buy that person out at whatever the market value is. And if that's not a good or an optimal situation, you're just going to have to continue to pay that person the distributions. Otherwise, they could come after you if you're not paying them, their rateable share of the profits. It kind of stinks, key man insurance. That's something Deborah mentioned. You definitely can fund. You can fund buy-sell provisions and buy-sell agreements with insurance products. I sell a lot of insurance. I recommend it for a lot of people. I'm not licensed to sell insurance, but it really is a very, very important piece of my business, making sure that my clients are covered. So, does that answer that question?
Very thoroughly.
Great.
Do we have any other questions for the group?
Can you throw your phone number up again, Brent?
Yes, I'll put my information in here in just a moment. I'll do my all my contact info.
I'll
I
just
also
throw out a
dropped it.
shout out too. Sorry, Scott, to interrupt. Throwing out a shout out just in general, why it's important. Being in the insurance industry, I do a lot of business lines on there. And when business goes south, especially with partners without any kind of contractual agreement or things like that, you'd be surprised how quickly a business will go under and how they'll just shut the doors. So always consult a lawyer to have it in writing what it is that you guys do, what the partners are capable of, what will happen in the event if someone decides they no longer want to be in the business or whatever.
If I could piggyback on that as well, a metaphor and a visual that I like to use when I discuss with my clients, how to make themselves as bulletproof as possible. There's no such thing as a true bulletproof force field, around yourself. But as much as possible, picture kind of like a dartboard with a bullseye. That innermost circle is your layer of protection that you need to set up. That's your legal structures, your contracts, making sure that the business is a business. You're not doing business with as yourself, so that any liability that attaches is going to attach to your business. An outer layer then would be insurance. So you protect the legal structures with insurances, key man, business interruption, commercial liability, umbrellas, all of those things are very, very important. And then outside of that, you have basically do no evil, do no harm, which is basically an easy way of saying, have your policies in place, make sure you're training. We talked about continuing education, make sure that your employees are doing their continuing education. I was listening to, the Growth Day app today, and he was talking about, don't be the lowest common denominator. I even wrote it up on the back to remind myself of that. Like we don't necessarily want to dumb things down. We want to bring people up. And so if you're training people as much as possible to be their best, then they're not going to, if there's no harm, then there's no liability. And if there is some liability, hopefully we have insurance that covers it. And worst case, if insurance isn't going to cover it, then you at least have the protections of your business, so that your 401k, your cars, your college fund, your investments, your house are protected from any business liability risk that might have attached, to your business and takes your business down. So those are kind of the steps, broad strategies that I would suggest to just protect yourself and your business. In order to basically be as successful as possible.
I like that. I like the way you thought about how it's prioritized and the visualization of the bullseye. Thank you.
And if anybody wants to hear a horror story about somebody who didn't have everything in place and the partnership separated, it was actually a corporation at the time, but that it separated. It was 20 years ago, but it was a nightmare.
Mm-hmm.
Okay. Thank you very much, Brent.